Hello, my name is Greg Fullilove. I'm a partner in Osborne Clarke's dispute resolution team. I am joined today by my colleague, Jeremy Summers, who is head of our OC business crime team. And Jeremy will be talking about some of the most far-reaching changes to the corporate criminal enforcement regime here in the UK for several decades. So first question, Jeremy, what are the changes that are coming in?
Thanks, Greg. Many listeners will be well aware of the corporate failure to prevent bribery and failure to prevent the facilitation of tax evasion offences. The government is now legislating to extend that genre of offence to include failure to prevent fraud. So when the new law comes in, if a employee or an agent commits fraud on behalf of the company, then the company, the commercial organisation, can also be liable for the standalone criminal offence of failing to prevent that fraud, unless it can show that it had reasonable procedures in place to prevent that wrongdoing from occurring. On conviction, a commercial organisation could face an unlimited fine and potentially confiscation of relevant profits. Two quick points to note, but they are important. Firstly, at present, the law will only apply to large companies, so not SMEs, but SMEs that are dealing with large companies are probably going to have compliance procedures in place that will satisfy the large organisations that they are appropriate to do business with. And secondly, it will apply to overseas companies if the fraud is committed by a UK individual or the victim of the fraud is a UK individual or UK entity.
That's interesting. So is the offence just related to fraud, or are there other forms of improper conduct?
Yeah, good question. No, it's not simply related to fraud. There are a range of economic crime offences involved: participation in a fraudulent business, false statements by directors, false accounting, fraudulent trading, cheating the revenue, so tax evasion, and a number of offences under the Financial Services and Markets Act of 2000.
That's a pretty long list. Are there any other changes that clients and businesses should be aware of?
Yes. In addition to the failure to prevent fraud offence, the government is legislating to make it easier to prosecute companies more generally. In terms of economic crime, outside of the failure to prevent offences, a company can only be liable for a criminal offence if the individuals responsible for the wrongdoing are of sufficient seniority to represent what's known as the directing mind and will of the company, sometimes called the controlling mind test. In the UK, at least, prosecutors have long complained that it's too hard in the model world of business to satisfy that test. The government have listened to that concern, and senior managers will now be brought within the ambit of the controlling mind test. So if a senior manager commits an offence on the company's watch, then in addition to the manager, the company can also be prosecuted for the offence.
So I suspect that a lot of people watching this are going to ask the question, what's a senior manager?
Very good question. It involves, or it is defined as an individual with a significant role in making management decisions about all or a substantial part of the organisation's activities, or actually managing or organising those activities.
All right, so in practice, what are these changes going to mean for our clients and business in general?
Well, interestingly, the changes are coming in at a time where we will have a new director of the Serious Fraud Office, a new director of public prosecutions, and so I think that the law may be used to herald a new era of more aggressive corporate criminal enforcement. So in the interregnum, I think all clients across all sectors ought to be looking at their risk assessments, looking at their policies and procedures, and making sure that they are protected as best they can for the risks that these new laws will present.
So Jeremy, when do these new laws come in?
Yes, both laws are contained in the Economic Crime and Corporate Transparency Bill. That is in its final stages of parliamentary debate. I would anticipate that the law will be in force, if not by the end of this year, then early part of next year. There is some guidance required for the failure to prevent fraud offence, but that can mirror the bribery guidance. But as I say, it is likely that this law will be here within, I would have thought, 6 to 12 months. So to all clients, use the time and, as I say, revisit your risk assessments, revisit your policies, make sure that you are as protected as you can be before the law comes in.
Jeremy, thank you very much, and thank you to all of you for watching.